Okay, so picture this. You've just landed a great new job, or maybe you're a business owner hiring a key person. You both sign the contract, you file it away. You think you're all set.
And that's where things get dangerous, because according to this new analysis from HTW Law, that piece of paper you signed, it might be legally worthless.
Worthless? I mean, that feels like a bit of a stretch.
It sounds dramatic, I know, but it's really the reality of Canadian law in 2026. The courts have become so strict that drafting these things is, and I'm quoting here, more of an art than a science.
So that's our mission for this deep dive. We are jumping into the minefields of employment law, specifically the booby traps hiding in plain sight, to figure out why so many contracts are failing.
And to do that, you have to start with the biggest minefield of all, the termination clause.
Right. I always just assumed that was boilerplate, you know? You have a with cause part for, like, serious misconduct.
And without cause part if it's just a layoff. That's how it used to work. But then Waksdale v. Swegon North America came along.
And that case triggered what our source is calling the just cause domino effect.
Exactly. The courts decided that these clauses are basically all or nothing. So in Waksdale, the employer's just cause section, the part for firing someone for bad behavior, was just slightly too broad.
Too broad how?
It technically could have allowed them to fire someone without notice for something that wasn't, willful misconduct under the law.
Okay, but if the person wasn't actually fired for that reason, why does it matter?
And that's the twist. The court said because that one part was potentially illegal, the entire termination framework of the contract was void.
Wait, the whole thing? Even the perfectly fine without cause part?
The whole thing. So one bad sentence about firing for cause can completely invalidate the part that limits severance pay.
Wow. And it's only getting stricter, right?
Right.
I see these 2024 and 2025 cases mentioned, Dufault and Baker.
Oh, yeah. The scrutiny is so intense now that the source literally uses the word impossible.
Impossible to write a valid contract.
Well, very difficult, if not impossible, to draft a termination clause that perfectly complies with the Employment Standards Act, or ESA. Any tiny ambiguity, the employee wins.
Okay, let's flip this around. Let's talk about getting hired. I was reading about this linkage problem in the Sui v. Hungry Panda case. This felt so familiar.
Let me guess. You get a quick offer letter by email, you say yes, and then a week later the real 40-page contract shows up.
Exactly that.
Classic situation. And the Sui case tells us that if that second, much longer contract isn't clearly and explicitly linked to the first offer, it might not hold up in court.
Because the deal was already made.
Precisely. It all comes down to a legal concept called consideration. You can't just unilaterally change the terms after an agreement is in place. If I want you to sign something stricter after you've already started, I have to give you something new of value.
Like a signing bonus or more vacation time.
Yes, something fresh. What I can offer you is just continued employment.
So an employer can't just come to you and say, sign this updated contract or you're fired.
Legally, that threat doesn't count as valid consideration. You already had the job. That new contract could be totally unenforceable.
That is a massive distinction.
Yeah.
Okay, one last area because it's everywhere now. The gig economy. Independent contractors.
Ah, yes, the old substance over form debate.
Right, so if I sign a document that says, I am a contractor in giant letters, am I a contractor?
Not necessarily. The law doesn't really care what you call it. It cares about the reality of the relationship. It's the duck test.
If it walks like a duck and talks like a duck.
It's an employee, and the courts have specific tests. First, control. Does the company dictate how and when you work? Second, tools.
Who owns the laptop and the software?
Exactly. If you're using their equipment, you look a lot more like an employee. And maybe the biggest one is profit and risk. A real contractor has a chance to make a profit, but also a real risk of financial loss.
And if I'm just getting an hourly rate from one company with no real risk,
then you're likely economically dependent on them. And if you are, the law sees you as an employee, and you're entitled to benefits and severance no matter what that paper says.
So whether it's termination or hiring or contractor status, it really sounds like the courts are just looking straight past the fine print to the power dynamic.
That's the perfect synthesis, really. There's this wave of strict scrutiny to protect workers.
Which leaves us with a pretty provocative final thought. If our legal source is saying it's now nearly impossible to draft a perfectly airtight termination clause,
then what does that mean for the millions of contracts signed 5 or 10 years ago sitting in filing cabinets right now?
If the new ones are failing this badly, the old ones might just be paperweights. Definitely something to think about.